So today we're going to continue to talk about the current state of ADA litigation in the United States in 2024. This is the second part of our presentation on this topic. Last time we looked at Usable Net's mid-year report, and today we're going to look at highlights from the accessibility outlook from Level Access. And this was presented by Corb O'Connor, who's the Director of Accessibility Advocacy at Level Access. He has 12 years of experience, many roles, both in development, coding, content, and program management. He's been an advocate for disability rights and has helped shape the regulatory legal landscape for accessibility. And the second presenter was Eve Hill. She's a partner at Brown, Goldstein, and Levy. She's a disability rights lawyer, has been doing this for 30 years. She's also been general counsel for the National Federation for the Blind, and she works in the digital accessibility space as well as in higher education. And in this part of the presentation, we're going to look at what are some of the more recent developments with federal regulations in 2024. U.S. regulations have become more specific with regards to disability rights and web accessibility. The Department of Justice released its final rule regarding the Title II of the ADA, which covers state and local governments as well as their vendors. And they set the standard to be WCAG 2.1 level A and level AA with deadlines in 2026 and 2027, depending on the size of your organization, whether you're smaller than 50,000 or greater than 50,000. Similarly, the H released a regulation under Section 504 of the Rehabilitation Act. This affects most colleges and universities and social service organizations that receive federal funding and also applies to their vendors as well. They also set the standard to be WCAG 2.1 level A and level AA with deadlines also in 2026 2027. Again, depending on the size of your entity, whether you have more than 15 employees or less than 50 employees. And both of these rules had exceptions. We went into greater detail in the previous presentation about the DOJ, but just to cover them quickly, archived content, pre-existing electronic documents, so old Word and PDF documents, pre-existing social media content, password protected, conventional electronic documents that are specific to an individual or account, and content posted by third parties, either individuals or organization, unless the third party is specifically contracted and licensed or otherwise arranged for it to be provided by the entity or organization. And in the case of a specific person requesting accessibility for a particular document, then these exceptions don't apply. So if you get a request about archived content from someone who has a disability who is requesting access to that content, then you do have to, this wouldn't fall under the exception if it's specifically requested by someone. At the state level, there are certain proposals. Colorado is looking at making sure technology that is purchased is accessible. So they are asking questions of vendors at the time of contract renewal and doing audits to make sure that the technology procured is accessible. Maryland is setting up regulations so that K-12 institutions must purchase accessible technology. There is an approval process to get an exception, but they're making it intentionally difficult so that most people would fall under this regulation. And then we are all watching California AB 1757, which is not yet passed, but is an attempt to hold third-party vendors accountable, including agencies that build websites. In the past, if a website was inaccessible, the only person who could be sued or responsible is the owner of the website. Typically, if the website developer, designer who helped the company create the website wouldn't necessarily be someone you could sue directly. Under this new proposal, they would be held accountable. And this resulted from a 2018 case where $60 million was spent for a campground website that ultimately was inaccessible. So the reason this proposal is in the works is because they don't want to repeat the situation where money already spent with a vendor resulted in a product that was inaccessible and they weren't able to really get that money back. So they want to make sure that doesn't happen again. This is where this law is coming from. But it has not yet passed, and but we're watching because it would change the space immensely if web platforms responsible for the websites are liable for the inaccessibility of the website. Internationally, the European Accessibility Act is expected by June 2025 to have wide enforcement. Each member state has been working on creating their version of the act for their country. They can be stricter than the agreed minimum standard, but they all have to at least hit that minimum standard. And they also have to have a plan for issuing audits and ongoing compliance every 5 years, with the first report with a deadline for 2030. This is targeting commerce to impact any type of commerce that impacts the lives of their private citizens. So we'll cover computers, smartphones, operating systems, ATMs, ticketing and check-in machines, digital TVs, phone services, any sort of passenger transportation services, bus, rail, air, water, banking services. It also covers e-commerce, e-books, and they have a standard EN 301-549, which is very similar to WCAG, but expands it, makes it more applicable to things like physical devices. And Canada has the Accessible Canada Act, and there's also the Accessibility for Ontarians with Disabilities Act, the OD. Both laws set clear technical standards for digital accessibility. They affect all U.S. companies that do business in Canada. AODA was the first provincial law to force accessibility standard and reporting requirement where companies who are larger than 20 employees are affected. Companies must make reports every 3 years starting in 2023. And any non-compliance results in a penalty of $100,000 per day, and fines for individual directors of those organizations are possible too. It was unclear to me if this was 100,000 Canadian dollars or US dollars. That was the amount of the penalty. Accessible Canada Act affects organizations with more than 10 employees with 3-year reporting requirements and has been enforced since 2018. Their goal is to be completely barrier-free by 2040. By using the language barrier-free, Canada is trying to be more inclusive of learning disabilities, issues with processing, and any type of neurodivergence. With regards to the actual litigation in the United States, we are seeing that the velocity of lawsuits is not slowing down. Last time we talked about how there might be a slight dip, but what Level Access is seeing is that it's about the same. It's not getting significantly slower. And there is an increase in lawsuits in the mobile app space. Whether you've received or not received complaints or demand letters isn't really a great barometer of your success with accessibility. They are finding that people will often go to a lawsuit first without even ever contacting a company about an issue. So whether you've received a complaint or not doesn't mean that you're doing a great job. So just keep that in mind. If you're not sure you're accessible, then you probably aren't. And you need to start taking a look at it. And the DOJ is targeting particular industries. And from last week, we know that the top industries are e-commerce, food service, higher education. What they're seeing with these lawsuits is that it's a back to basics situation, that it's the simple things that people are missing. Really, these are things that everybody should be trying to get taken care of. And these are things that are typically not that difficult to fix if you're aware that these are issues that you need to take care of. So alternative text, making sure your images have alternative text descriptions, color contrast for those who have low vision. You want to make sure that the colors you choose in your color palette have enough contrast between them that they can discern a difference. Keyboard focus. Some people navigate using their keyboard, and so there has to be an ability to navigate to your website using a keyboard only. Your links need to be labeled properly so people know where they're being sent. And also, if you have a form, need to be labeled properly so a person who is primarily using a screen reader can understand what type of information you're seeking in your form. And tables have always been a complex issue with accessibility, so making sure your tables are accessible. And there was a case with Target. Alternative text was an issue in 2006, and it's still an issue in 2024. So these are things that we need to make progress on. And the retail industry is still struggling to comply with basic PDF tagging. The PDF documents that you have downloadable for your websites are also covered under digital accessibility. The PDFs need to be produced in a way such that the PDF can be read by a screen reader, and this requires a special way of doing exports from various programs like Word or InDesign, and also directly removing the PDF itself for accessibility. Sites that frequently have content changes struggle to keep alternative text up to date. Accessibility isn't a do it once and you're done type of thing. There needs to be ongoing auditing of your site. And if you're someone who is always updating your site with new images or new media, and whoever is responsible for updating the new content also should be trained to make sure that content is being uploaded with alternative text. Um, in the case of videos or audio, that there are transcripts and closed captioning. Higher education is continuing to struggle, especially in light of these new rulings. So there has been a focus on higher education, and many institutions are doing better, but they're still struggling to fully comply. We're also seeing strategic filing in particular state courts. And just to reiterate, even if your business is not located in these states that are highlighted, it doesn't mean you can't be sued. If you have people who are customers from those states that frequent your website, if you're a national website, then you could be affected by litigation that's increasing in particular states. So New York and Florida are places where you might see increased filing. New York and New York City have specific human rights laws with monetary damages available in some cases that make it an attractive place to file a lawsuit. However, this New York Southern District Federal Court is a little bit more hostile to these cases because there's too many what they call cookie cutter complaints, the same complaints over and over again, but they aren't well thought out. And many of the judges are questioning whether the person that is putting these cases up has adequate standing. Because some of the plaintiffs' firms, what they do is they have serial testers going in there and just checking sites, filing suits against any site that they see errors on. But these testers aren't really customers of a site, and that is an important distinction where this New York Southern District is expecting that the plaintiff is a real customer that's trying to achieve a particular action on a website and can't do it. And that's why they've been harmed, and that's why they are suing. They aren't being particularly friendly to these kind of cookie cutter complaints that are a result of serial testers just checking every site that's out there and filing complaints if they're finding things. Florida is attractive because there's a particular plaintiff's firm that is located in Florida that is known to file these types of complaints. So Florida is seeing a rise in the cases filed there. Pennsylvania has a wide definition of pain and suffering that makes it an attractive court to file in for plaintiffs. Minnesota also has a large plaintiffs firm similar to Florida, and so that's why they have an increase in filings. There's a civil rights law in Illinois from 2007 that focuses on IT procurement. So cases of that nature are popular to be filed in the state of Illinois. And different from previous with Usable Net's report, they noted New York and California to be top states. Level Access finds that California has dropped to fourth place. This may be attributed to some changes in the Unruh Act, which is a civil rights type of act, and that may be why the cases have changed there. They have also had a couple of instances where they've thrown out cases by testers. The chambers of commerce in California are actively working with businesses to help them try to, rather than settle outright, to fight cases that may be possible to be thrown out on issues of standing. And some emerging trends, there are many businesses now that try to use kiosks to do automated check-ins. You see these often in doctors' offices, hospitals, and been a recent focus on whether these kiosks are accessible. So if you're someone that's using some sort of kiosk at your business to maybe do a preliminary check-in for people, you better make sure your kiosk has is accessible, because there was a recent controversy when Social Security rolled out kiosks that ended up being inaccessible, and all of them now need replacement, which of course was a huge expense for Social Security. And then there is an emerging trend of increasing cases with regards to internal employment software. For example, the medical field, where there's electronic health records, or customer service that might use some sort of internal application for the employees to do tasks for the customers. And the reason is becoming a rising issue is it becomes an Equal Employment Opportunity Commission issue or violation, because the EEOC's regulations are responsible for making sure that people with disabilities have equal access to employment or support, especially those who are blind or with vision impairments. They can't work a job because technology at that job is inaccessible. That becomes a discrimination against those with disabilities. So we're seeing increased cases where the EEOC is finding that people are not an equal employment opportunity because the technology that a business has is not accessible. This becomes a big issue, especially that type of employer, someone that typically does employ people with disabilities, and now those same people can't do their jobs anymore and are losing work. And with regards to, we are seeing again the potential for an EEOC issue, because AI is increasingly being used in the hiring space to screen applicants from jobs. And AI may discriminate on the basis of disability because it's learning on data that doesn't include much about people with disabilities. So there's bias produced into the AI models because the data that they are learning from is not friendly to people with disabilities. And an example would be, sometimes there are assumptions made by people who aren't making good eye contact. There are certain disability conditions where people will not make eye contact. It has no reflection on their character or anything like that. During their presentation, they went into what makes you a target for litigation. And these were the points that can make you someone who is more likely to get a lawsuit if you are found to be inaccessible. Number one, your importance to people's lives. Because if you're a business that people have to use your services to get things done, it raises your visibility. And you're more likely to be challenged by someone who can't do what they need to do on a website. Your ubiquitousness. If you've actually cornered your market, that may not be a good thing, because if you're the only game in town and you're not accessible, then you're going to attract more attention. And deep pockets. Are you someone that has the money to pay the fees or the damages associated with these lawsuits? More likely to be targeted. Employment potential. Are you an industry that is involved with customer service, health? Are you someone who would be a huge employment potential for people with disabilities? Do you have work at home opportunities? Because transportation is a huge barrier for people with disabilities, jobs that offer work at home options become increasingly important to those with disabilities. And if they can't get employed by you because you don't have accessible technology, then that becomes a problem, becomes an EEOC issue. And the location of your web presence. Are you in a top tier state for litigation? So what if you get a demand letter or a complaint? How should you respond? You should respond immediately. Don't ignore it. We learned that from last time. Because you want to take advantage of this opportunity. They've made a complaint. if you handle it proactively to resolve the issue, you can set a timeline for fixing issues on your site. You can avoid litigation. If you avoid litigation, you set the timeline, you can keep your fees down. And that will, a lot of times it'll depend on how outrageous the violation is. How important is it for the problem to be fixed right away? Because if it's a critical issue and your technology, your website is important, then you won't be able to delay as much as another business maybe that provides a service that's less necessary. What are some of the notable cases that have come out recently? Loberbright Enterprises versus Raimondo, the Supreme Court overruled their landmark 1984 decision in Chevron versus National Resource Defense Council, the NRDC. This happened in June. They overruled their decision in Chevron. This basically cut back the power of federal agencies to interpret laws they administer, so that now courts can rely on their own interpretation of laws that may be ambiguous. So basically, in the past, when a law was not clear or ambiguous, the federal agency interpreted in a particular way, courts would generally defer to that agency's interpretation, assuming that the agency had more expertise in that area. And as a result of it being overturned, now courts have more of the power to set the definition of these ambiguous statutes and regulations. And Corner Post versus the Board of Governors of the Federal Reserve. This basically extended the deadline by which you can challenge a regulation for being arbitrary or capricious, or for being wrong in its interpretation of federal law. And the statute of limitations now starts when an entity experiences a problem with a regulation. So since an entity can experience a problem with a regulation at any time, this basically extends the statute of limitations to forever. So this can invite more entities, just like the Chevron issue, to challenge the ADA regulations and the 504 regulations. Arguments against trying to do this would be that the ADA has been issued and amended by Congress, and they didn't do anything to change those regulations, so it's essentially reaffirmed them. But in the end, courts are probably still going to continue to turn to federal agencies because the courts just don't have the expertise that some federal agencies do. And entities that do want to challenge the regulations will have a hard time because they then have to come up with their own standard. And that would be a challenge to internationally accepted standards by the WCAG. And if you're going to create your own rules, regulations, that's going to cause litigation costs to skyrocket because you have to bring in your own experts in order to create your own set of rules and regulations and try to challenge widely accepted standard, the WCAG. Theoretically can be done. It's probably unlikely, but these are some court cases that made it a possibility. So we'll keep looking. And then Payan versus the LA Community College District case was basically a situation where blind students were unable to be provided with accessible documentation and course materials. They couldn't access library resources, and they did not have accessible educational technology in classroom. They have taken this case to trial twice, and both times plaintiffs won with damages. And basically, people have said in the time that they spent litigating this case, the college probably could have made the material accessible 5 times over. So it's unclear why they continue to appeal, but they do. And even though they've lost twice, and they are going to appeal again, and material is still not accessible. So they are still harming these students and other blind students in education. The judge has issued an injunction that requires them to get accessible within a year. So this just shows, again, when you let things go to court, you lose control of the timeline. So they lost control of how much time they have to take care of things. So this is the difficulty with trying to challenge. If you've attended my Web Accessibility Challenge in the past, and we had a guest speaker, Nancy Boudreau, who worked higher education for some time, and she worked with the university, received a similar complaint, but they chose immediately to not fight it because they knew that they had issues. They weren't serving their students, so they went ahead and they hired experts to come in, and they managed to make great improvements. And what they found is that by making their website accessible, they helped the experience for not only those students with disabilities, but they help the experience for everybody. So it's interesting that this particular college is choosing not to continue to fight this and not make the changes needed to make themselves accessible. In an interview, a plaintiff from another case, which involved a major college, said that in the end, I got a legal victory, but I didn't get a great education, and I'm not convinced that the students after me are going to get a great education either. Even though she won her case, in the end, she loses because she didn't get a good education. And this does cause reputational harm to the college university. People with disabilities are known to be great advocates, and this will reflect badly on the LA Community College for not being proactive and trying to help their students with disabilities. People talk about how you handle accommodation requests, and that's the case too in higher education. Another case is Orozco versus Barrett Garland. And this was a case where a federal employee who was blind was given inaccessible technology to work with. This technology was necessary for their job, so they had to work with it and had to find a way to work around. And in Section 508, under this ruling, you're supposed to provide people with accessible technology. It doesn't say that you can buy technology that's not accessible and expect your employees to be adept enough to create workarounds around the barriers. Your technology should be accessible to begin with. But what this case showed is that, can federal employees actually sue their employers, meaning the federal government, or do they need to ask for accommodation first, or is asking for accommodation their only outlet? But this showed that you can actually pursue legal action in court even when you're fighting your own government under Section 508. And this just showed how there are failings with Section 508. Section 508 has been around for a while, but the GSA, the General Services Administration, is supposed to be doing an evaluation of every agency's web presence publicly and annually. So it showed just our own government's failing doing what it needs to be doing for accessibility. So there has been a law, the 508 Refresh Act, that's been proposed by Senator Bob Casey from Pennsylvania. And this puts the spotlight again on accessibility and 508 compliance. The idea is to provide a framework to hold agencies accountable for accessibility requirements. So what are some of the final key takeaways regarding ADA litigation? If you haven't received a demand letter, it's probably only a matter of time. If you don't know whether your website's accessible, probably isn't. If you know it isn't, you need to be working on it. And you should do this while you have control over how and when you get it done. Litigation forces a rapid time will cost you. Even though the Chevron doctrine may be over, it doesn't mean that the WCAG is not the standard. There is no other standard right now. And if you're going to try to come up with your own, the speakers of the talk basically wish you luck, because it's going to be expensive to do and then prove it's just as good as the WCAG. And also Section 508 puts spotlight on the vendors. So vendors need to be on alert. Whatever you're providing the government, needs to be accessible, or you will no longer be someone who you can contract with. You will probably lose your government contract. So don't wait. Start now. Aim for conformance with WCAG 2.1 level AA. While there is already a WCAG 2.2 level AA, it probably won't be adopted until the next round. Create policies and processes within your organization to prevent the creation of new barriers. It's not a one and done thing, an ongoing process. Websites are dynamic, and it's a much more expensive process to fix it after the fact. It's better to be accessible from the beginning, implement training for your technical people, but also your non-technical people, the content creators, anyone responsible for making posts. They need to know how to make sure things are accessible. And you want to partner with experts and people with disabilities, because you not only want things to be accessible, you want them to be usable. You want to prioritize accessibility like you prioritize privacy and security in the past. You must address it early and often. What are some of the tech takeaways from the Q&A? Review your multi-year agreements with your partners. Are the products accessible? Because in most cases, you only have a 1 to 2 year time to become compliant, and you may have to abandon an inaccessible product midway and bring in a new vendor, which will be expensive to use. So review all your multi-year contracts. Make sure you're compliant, they're compliant, so that you can keep working together. If you're in higher education, payouts are running from thousands of dollars to hundreds of thousands of dollars, because higher education websites are complicated. And it also is a situation where it depends on how much you've interfered with a student's education. If you've delayed a degree because you're not accessible, they can't get their education, there are consequences to that. While under Cummings versus Premier Rehab Keller PLLC with 504, you can no longer get emotional distress damages, there are still these educational opportunities damages. The years where this person is unable to make a salary because they couldn't get their degree or they couldn't get the education they need, is going to result in significant damages. There's going to be a good deal of enforcement in the next 2 years, because it will be easier to tell that you aren't compliant with WCIG. Right now, there's no dispute about the standards, despite some of these cases we brought up. There was a question about whether responding to a demand letter opens you up to more liability because you're admitting that you're culpable, like that you know that you're not accessible. But the feeling is that you should respond, and you should respond early, because litigants will be more likely to be patient to know if you admit fault and you show analysis, you let them know what your plan is, you set the timeline, and it looks reasonable. Taking any sort of action usually discourages further litigation. And then when you're not getting a formal legal document, a complaint, when you're just getting feedback from people, try not to just send generic response back. Use it as an opportunity to do proper testing. Compare your results with the customer and tell them how you will do better. Just keep in mind, most people with disabilities are not interested in suing anybody. They just want to be able to use your website. And they want to feel respected and understood and shown that their needs are a priority. So if you are respecting them enough to listen to their concerns and do something about it, you're less likely to face litigation. They want to be able to do business with you, and your response to their complaint will help them know whether you're someone that's worth doing business with from their end.